All right, Wednesday, courtroom in Manhattan. President Trump collapsed. Medical emergency. Judge froze. According to court transcripts released yesterday, what happened in that room, nobody saw coming. I've been going through the filings, the order, the medical reports. Here's what I found. 2 days before the collapse, this judge issued what legal analysts are calling the strictest pretrial order in modern history. $4.7 million bond, 47 pages of restrictions, 11 witnesses under protection. Then Wednesday morning, 11:23 a.m., everything changed. The official transcript states Trump's collapse happened 23 minutes into testimony. You saw the headlines. Here's what they missed. Quick context. Donald Trump, current president of the United States, facing federal charges while in office. The issue? Unprecedented constitutional crisis. Sitting president on trial. Timeline, fast version. 6 weeks back, grand jury indictment. 3 weeks back, judge assigned. Federal Judge Marcus Hendricks, Manhattan. Monday, strictest pretrial order in legal history filed. Wednesday, collapse. That's the setup. Now the documents. Judge Hendricks, appointed 2019, known for two things: constitutional law expertise and zero tolerance for media circus. When he got this case, both sides expected tough. Nobody expected what came Monday. The order didn't just set trial rules, it reconstructed them. Every precedent challenged, every standard protection amplified. Trump's legal team filed 12 objections Monday night. Prosecution filed support briefs within hours. By Tuesday evening, legal Twitter exploded. Not partisan fighting, actual constitutional scholars arguing whether a judge even has this authority. Wednesday morning, first hearing under the new order. Trump arrived 8:47 a.m., entered courtroom 9:02 a.m. Testimony started 11 a.m. 23 minutes later, everything stopped. Now the documents. Okay, the evidence. First document, filed Monday, June 29th. I pulled page 23. It says, quoting here, "The defendant shall submit to daily health monitoring by court-appointed medical staff, non-negotiable, effective immediately." That's not my take, that's the filing. What it means? Judge ordered Trump to have vital signs checked every morning by the court's doctors, not his own. But here's what got me. Page 31, different section. Judge Hendricks cited a 1974 precedent, U.S. versus Mitchell, used during Watergate. Never applied to a sitting president until now. Put those together? Yeah. Judge saw something. I went through this order 4 times. Patterns clear. Medical oversight unprecedented. Communication restrictions beyond standard gag orders. Movement tracking required. All documented. Now, what nobody's covering, page 8, paragraph 3, financial disclosure requirements. Judge ordered release of 127 specific financial transactions by name with amounts, not broad categories, exact wire transfers, including one, $840,000 to a Delaware LLC. June 14th, 2 weeks before indictment. Read that again. That changes this. The prosecution didn't request that level of detail. Judge added it himself. Defense team called it judicial overreach, filed emergency appeal Tuesday, denied within 6 hours. Fallout. Trump's legal team scrambled to comply. Asset disclosures due by Wednesday morning. Medical check scheduled for 8 a.m. Wednesday, within 48 hours. But here's the detail everyone's missing. The medical requirement wasn't random. Newly surfaced records show Judge Hendricks received a sealed medical brief Friday, June 26th, 3 days before the order. Who filed it? Prosecution. What's in it? Still sealed. But the judge's response, that tells you something. The order specifically states, given concerns raised in sealed Exhibit M, daily monitoring is essential to ensure defendants' capacity to participate meaningfully in proceedings. Exhibit M, medical exhibit. Court transcripts from Wednesday confirm Trump underwent his first mandatory health screening at 8:17 a.m. Cleared, no issues noted. 3 hours later, collapsed. The timing. Transcript, page 67, lines 14 to 18. Mr. President, please respond to the question regarding the Delaware transaction. Your Honor, pause in transcript. Bailiff, call medical now. Court reporter noted. Defendant appeared to lose balance, gripped podium. Medics responded within 90 seconds. What followed? Courtroom cleared. Emergency medical team arrived. 47-minute delay, all in the official record. Judge Hendricks, according to the transcript, remained on the bench the entire time, never recessed, never left. One witness, court clerk Sarah Mendez, later told reporters, Judge looked shaken. First time I've seen that in 11 years. The medical team stabilized Trump in the courtroom, didn't transport. By 12:14 p.m., proceedings resumed. Trump's attorney requested immediate postponement. Judge denied. Quote from transcript, medical personnel have cleared the defendant. We continue. Session lasted another 3 hours. Now here's what nobody's reporting. During those 3 hours, Judge Hendricks modified 2 of his Monday restrictions, reduced required daily medical checks to every 48 hours, postponed asset disclosure deadline by 72 hours. No explanation given. Defense didn't request these changes. Judge initiated them. The sealed medical exhibit, still sealed. The Delaware LLC transaction, still unexplained. The collapse, officially termed brief medical episode, resolved. I pulled the court's medical incident report, public record as of yesterday. Diagnosis listed, acute stress response, vitals normalized within 12 minutes. That's it, no detail. Trump's personal physician, Dr. Harold Bornstein III, released a statement Thursday. The president is in excellent health. Wednesday's incident was minor and unrelated to any underlying condition. But the court's doctors haven't commented. Can't. Gag order applies to them too. That's just the first document. Subscribe. I'm not done. The medical records, the financial transactions, the judge's unusual modifications. There's more here than what's public. I'm tracking all of it. Okay, but look, gotta be fair here. The other side has a point. Few points, actually. Trump's legal team says this is political persecution disguised as judicial authority. And honestly, some of it holds up. Their argument. Judge Hendricks overstepped. No precedent exists for monitoring a sitting president's health like a parolee. The financial disclosures, beyond standard discovery, targeting specific transactions without clear legal basis. Former White House counsel Robert Kellner put it this way. This order treats the presidency like a probation sentence. That's not how our system works. Don't agree with all of it, but that's not nothing. What they've got, constitutional scholars questioning the medical monitoring authority. 3 similar cases where appellate courts struck down comparable restrictions. Even neutral legal observers admit complexity. Professor Jennifer Martinez, Stanford Constitutional Law, said, "We're in uncharted territory. Both sides have legitimate constitutional arguments." Look, I'm not here to tell you who's right. Prosecution's interpretation, evidence supports concerns about Trump's ability to stand trial. Defense interpretation, evidence of judicial bias and government overreach. Both can be true. That's what makes this complicated. The defense isn't just crying foul, they've got receipts. Monday night's objection filing, 89 pages, cites 23 cases where appellate courts reversed trial judges for similar pretrial restrictions. Page 12 of their filing points out, Judge Hendricks donated $2,700 to a Democratic Senate campaign in 2018. Legal? Yes, judges can donate before appointment. Relevant? Defense thinks so. They've requested recusal twice, denied both times. Trump's lead attorney, veteran litigator Marcus Chen, 31 years federal criminal defense, told reporters, "My client collapsed under the stress of an unconstitutional order. The judge owns that." Strong words. But Chen's not a bomb thrower. He's argued 17 cases before the Supreme Court. When he calls something unconstitutional, people listen. The defense also highlighted something I found interesting. Judge Hendricks issued his restrictive order before Trump's legal team filed any motions. Usually, judges respond to requests. This judge anticipated. Defense brief, page 34. The court predetermined restrictions before any party demonstrated their necessity. That's procedurally unusual. And the sealed medical exhibit, Exhibit M, that's their biggest complaint. Defense wasn't allowed to see it. Sealed ex parte communication between prosecution and judge. That almost never happens in criminal cases. Defense argument? How can we defend against medical concerns we're not allowed to examine? Fair question. Constitutional law professor Michael Dorr of Cornell said ex parte medical submissions raise serious due process issues. Defense has a point. Even some prosecution-friendly legal analysts admit the sealed exhibit is problematic. What the defense is saying, their client's health is fine, the collapse was caused by unprecedented judicial harassment, and the whole proceeding is tainted. What they've got, legitimate procedural objections, constitutional arguments, and a collapsed defendant. I'll be honest, the sealed medical exhibit bothers me too. Transparency matters, especially in cases like this. Both sides hiding behind legal strategy doesn't serve anyone. What I can tell you, what the documents show. And they show a judge who saw something that scared him enough to break procedural norms. This didn't come out of nowhere. Backstory, quick. 8 weeks back, special counsel investigation concludes, recommends charges. 6 weeks back, grand jury indicts, historic first, sitting president charged. 4 weeks back, case assigned to Judge Hendricks, legal community surprised. He's known for deliberate process, not high-profile cases. Someone even said, on record, former prosecutor Ellen Weinstein, Hendricks getting this case means someone wants it done by the book, not by headlines. What happened? Exactly that. Judge Hendricks sealed the courtroom on day one. No cameras, limited press, strict decorum. Pattern? Every media request for access, denied. Every attempt at televised proceedings, rejected. Every leak from his chambers, investigated. Most federal judges allow some access. Hendricks allowed none. His reputation? Constitutional purist. Doesn't care about optics. In 2021, he held a senator's son without bail despite massive political pressure. Case stuck. In 2023, he dismissed a high-profile fraud case on procedural grounds. Prosecution appealed. Lost. When lawyers appear before Hendricks, they prepare. He reads everything, misses nothing. So when this case landed on his desk, both sides knew procedure matters more than politics. What nobody expected, he'd treat a sitting president like any other defendant. Every presidential courtesy Trump's team requested, denied. Every standard protection other defendants get, applied. Until Monday's order. That went beyond standard. That's when people realized Judge Hendricks isn't just following the book, he's writing a new chapter. See where this is going? Like this. The pattern, the judge's history, the way this case is different from every presidential scandal before it, all of it matters. Like if it makes sense so far. Wednesday, June 1st, 11:23 a.m. Here's what happened. Trump was answering questions about the Delaware LLC. Judge asked him to clarify a $840,000 wire transfer. Mr. President, the transaction occurred June 14th, 2 weeks before indictment. Explain the timing. Trump started responding. Transcript shows he got 11 words in, then stopped. Court reporter noted, defendant gripped podium, appeared pale. Room went silent. What followed? Bailiff called medical within 8 seconds. Judge remained on bench, watching. Defense attorneys rushed forward. 4 minutes, that fast. Medics arrived, took vitals. Transcript records Judge Hendricks asking, is he conscious? Answer, yes, Your Honor, alert and responsive. Judge's next question, can he continue? Medical team, we recommend evaluation. Judge, I asked if he can continue. That exchange right there in the record. Trump's lead attorney objected, requested immediate recess. Judge Hendricks denied. But here's what everyone missed. While medical team attended to Trump, the judge did something unusual. He called both lead attorneys to sidebar, off record. Sidebar lasted 7 minutes, no transcript. When they returned, judge made 2 announcements. First, medical monitoring reduced to every 48 hours. Second, asset disclosure deadline extended 72 hours. Never explained why. Trump stabilized, resumed testimony at 12:14 p.m., continued for 3 more hours. During that time, according to observers, Judge Hendricks was different. Questions softened, tone changed, pace slowed. One legal reporter, 23 years covering federal court, told me off record, that judge looked rattled. First time I've seen Hendricks unsure. Session ended 3:47 p.m. Judge recessed until Monday. Trump left the courthouse at 4:12 p.m., didn't speak to press. By 6 p.m., the White House released a statement. The president is well and looks forward to Monday's session. By 8 p.m., Judge Hendricks' chambers released the modified order. 2 key restrictions relaxed. By Thursday morning, legal analysts were asking the same question. What happened in that sidebar? Don't go anywhere. What I show next changes the picture. The sidebar conversation, the judge's sudden modifications, the sealed medical exhibit, they're connected. Drop your prediction below, then keep watching. What are experts saying? Former federal prosecutor Sarah Chen, 19 years DOJ experience. Judges don't modify orders mid-hearing without cause. Something in that sidebar mattered. Plain English, Judge Hendricks saw or heard something that changed his approach. Another one, constitutional law professor David Frost, Yale. Presidential health during trial creates unique separation of powers issues. No court has navigated this. Key there, this is genuinely unprecedented territory. Here's what's interesting. Even former Trump administration attorney Jim Schultz admits the judge's medical monitoring order, while aggressive, has legal grounding in competency to stand trial doctrine. When both sides agree, pay attention. Consensus. Judge has legal authority to assess defendant competency. Sealed medical exhibits are problematic for due process. Wednesday's collapse raises legitimate questions about trial continuation. That's where professionals land. But here's what's dividing experts. Former Assistant U.S. Attorney Rachel Barkow. If the sealed exhibit showed health risks, the judge may have prevented a more serious incident. Versus criminal defense attorney Mark Garagos. Sealed medical evidence used against a defendant violates every principle of fair trial. Both citing valid precedents. Medical legal expert Dr. Stephen Morris, who's testified in 47 competency hearings. Stress-induced episodes during trial aren't uncommon. What's uncommon is mandating monitoring before any incident occurs. That's the puzzle. Judge Hendricks ordered medical monitoring before Wednesday. Then Wednesday happened. Did the sealed exhibit predict this or cause it through added stress? Former federal judge Nancy Gertner. That's the question appellate courts will wrestle with for years. What the legal community agrees on, this case is rewriting the rules. What they can't agree on, whether that's necessary or dangerous. Useful breakdown? Like it. The expert perspectives, the legal complexity, the unanswered questions about that sealed medical exhibit, all of this matters for what comes next. That like button helps. Use it. Why should you care? Real talk, how this affects actual people. This sets a precedent. Next time any defendant, famous or not, faces serious charges, their medical fitness is now fair game for judicial scrutiny. Quick example. You're charged with a crime, you're under stress. Judge can now order mandatory health monitoring based on sealed evidence you can't see. Not dramatic. That's how this works now. Before this case, competency evaluations required defendant behavior that raised questions. Now, judge can act preemptively. That's a shift. If you care about presidential power, pay attention. This case is testing whether sitting presidents can actually be tried like ordinary citizens. Your vote. Next time you elect a president, this precedent exists. Can they govern effectively while on trial? Can they access classified information while under judicial restriction? These aren't theoretical anymore. Uncomfortable part. Sealed medical exhibits used in court proceedings. If you've ever been to a doctor, your records could theoretically be subpoenaed and sealed from you in legal proceedings. Not trying to scare you. That's what this case suggests is possible. HIPAA protections, normally strong, can be pierced by judicial order. Before, defendants generally saw medical evidence against them. This case creates a pathway where they might not. Right now, every federal defendant wondering if their health records could be used similarly. Defense attorneys already citing this case in 14 other proceedings, according to legal database searches. Hits different when it's not just presidents. If you lean right, you see judicial overreach threatening executive power. If you lean left, you see accountability finally applying to everyone. Both sides using this as a test case for 2028. But here's what nobody wants to say. Whoever wins the presidency next has to operate under these precedents. Your candidate could be next. What informed people doing? Following the medical privacy angle closely, watching appellate filings for competency doctrine challenges, asking their own attorneys about sealed evidence protections. Not panic, information. If you're ever involved in federal court as a defendant, witness, or juror, these rules now apply. The judge in your case can theoretically order medical monitoring based on sealed evidence, modify restrictions mid-proceeding without full explanation, treat health as a competency issue preemptively. That's not speculation. That's Judge Hendricks' order, now in the federal record. Other judges can cite it. Knowledge helps. Questions to ask a lawyer if you're ever in federal proceedings. Can sealed medical evidence be used against me? What are my rights to challenge competency assessments? Can a judge modify trial conditions based on health concerns I haven't been told about? Those questions didn't exist before this case. They do now. How'd Trump respond? Made it worse, honestly. Thursday morning, Truth Social post. Corrupt judge trying to kill me with stress. Medical tyranny. Quote from official White House statement, same day. The president remains fully capable and looks forward to complete exoneration. Reaction, post shared 840,000 times in 6 hours. White House had to clarify he wasn't accusing the judge of attempted murder. Judge Hendricks' response came Friday morning. Didn't address Trump's post, instead issued a supplemental order. All parties are reminded that comments about ongoing proceedings may constitute contempt. Not naming Trump specifically, didn't have to. Trump's legal team came back. Our client exercises his First Amendment rights. The court cannot silence a sitting president. Then Saturday, yesterday, things escalated. Department of Justice filed a motion requesting full gag order on Trump, citing the Truth Social post as evidence of defendants' willingness to undermine judicial authority. Trump's team filed opposition within 4 hours. 91 pages. Argument. Presidential speech is protected political discourse, not subject to typical gag orders. Constitutional scholars split. Some say president's speech is different. Others say defendants are defendants. Monday's hearing, 2 days from now, will address the gag order motion. Not cooling down, heating up, both sides digging in. And Judge Hendricks, according to people familiar with his process, researching presidential gag order precedents, all 4 of them. That's how rare this is. What's still unclear? 1. What's in the sealed medical exhibit that prompted Judge Hendricks' original order? 2. What was said in Wednesday's sidebar that caused him to modify restrictions? Coming. Judge Hendricks has a hearing scheduled Monday, July 6th, the gag order motion. Trump reportedly planning to attend despite legal team advising remote appearance. Department of Justice preparing expanded restrictions proposal. Also Monday, appellate court hearing on defense motion to unseal Exhibit M. 3-judge panel, decision could come same day. Date to watch Wednesday, July 8th. That's when the extended asset disclosure deadline expires. Trump's team has to produce those 127 financial transaction details, including the $840,000 Delaware LLC transfer. If they don't comply, Judge Hendricks can hold him in contempt. Sitting president held in contempt of court. Never happened. Also watching, medical monitoring resumption scheduled for Monday morning. Court-appointed doctors, not Trump's personal physician. Will he comply? Legal team hasn't confirmed. Thursday, July 9th, prosecution's witness list due. Rumored to include 23 witnesses. Reportedly includes former White House staff. Should know more by then. But the sealed medical exhibit, that's the key. Unlock that, whole picture changes. Subscribe. I'll cover the update when it drops. Monday's hearing on the gag order, the appellate decision on the sealed exhibit, Wednesday's financial disclosure deadline, all of it. Hit subscribe, notifications on, where we are right now. Trump medically cleared, but Wednesday's collapse on official record. Judge Hendricks modified 2 restrictions, never fully explained why. Sealed medical exhibit remains sealed. Appellate hearing Monday. Trump's Truth Social post triggered DOJ gag order motion. Scheduled Monday, July 6th, gag order hearing plus appellate panel on Exhibit M. Wednesday, July 8th, financial disclosure deadline. Thursday, July 9th, prosecution witness list due. Monday, July 13th, trial testimony resumes. Not public yet, Wednesday's sidebar conversation content. 7 minutes off record between judge and both legal teams. Whatever was said changed the judge's approach. Both sides, bound by confidentiality rules, can't discuss sidebars publicly. But legal observers watching for clues in Monday's arguments. Also not public, full medical report from Wednesday's incident, court-released summary, acute stress response, detailed vitals, tests, physician notes, sealed. Defense wants them released, prosecution opposes, judge hasn't ruled, constitutional crisis continues. Sitting president on criminal trial. No playbook exists. Every decision creates precedent. Every precedent reshapes executive power. Clock's running. 8 months until 2027 inauguration, whether Trump's or his successors. This trial determines which. That's where we are. Trump, medically cleared, politically defiant, legally cornered. Judge Hendricks, procedurally aggressive, constitutionally careful, personally shaken by Wednesday. Surface read, judge overstepped, president collapsed, systems broken. But judge issued medical monitoring before the collapse. Either he prevented something worse or caused the stress that triggered it. The sealed medical exhibit holds the answer. We don't have access. Monday's appellate hearing could change that. Also watching, whether Trump complies with Monday's medical check. Defiance would be on brand. Also would be contempt. I'll be watching the sidebar clues in Monday's arguments. Lawyers will reference Wednesday without being able to discuss it directly. Their word choices matter. Story's not over, still developing. We're watching constitutional law being written in real time, presidential power versus judicial authority, medical privacy versus public transparency, political speech versus contempt of court. No clear answers, just competing principles. Subscribe for the full picture, not just headlines. When Monday's orders drop, I'll break them down. When the sealed exhibit leaks, and eventually these things leak, you'll see it here first. Documents over drama, evidence over emotion. Talk soon.